Hello everyone, my name is Cathryn Costello and it's a great honour to be giving this keynote lecture at the 14th conference of the Network Migration Law. I took the invitation very seriously, it's a great honour, and I found your title intriguing. So I am in the lecture going to very broadly reflect on law at borders and the question you pose, whether those are also the borders of law. In doing that, I'm going to very broadly try to do three things. So what I intend to do is start with some very general opening comments about laws that are applicable to migration controls. And in the second part of my lecture, as I'll illustrate, and I think this is an insight which probably all of you as migration lawyers are very aware of, I'm going to reflect on the multi-sited nature of the border, that there are very many different sites of border controls. Many of them are extraterritorial, but many of them are also within countries and indeed bear down within states, within communities, and even in families. And reflect on the different ways that law works at these borders. And then I'm finally going to conclude with some very general reflections on the rule of law in migration control in the section that I've called Rule of Law Redux. What I want to do there actually, and I'll just put it at the opening of the lecture as well, is think not only about the rule of law in terms of accountability, which I think is of course very important in this context, but also the conduct guiding function of the rule of law. So all accounts of the rule of law, and indeed its sister concept, the Rechtsstaat, have lots to say about authority being constrained, being guided by rules of different sorts. But also, most accounts of the rule of law are concerned about the conduct guiding function of law, that individuals should be able to meaningfully orientate their behavior around the law. And I think that aspect of the rule of law can also give us some important insights into some of the deficits of the rule of law in relation to migration control. So first of all, some very general comments on law in this context. Obviously, we want to be concerned about human rights at borders. That goes without saying. But I want just here to put out a reminder that human rights extend beyond non-refoulement. And in this lecture, I will allude to non-refoulement, but I also want to think about non-discrimination and equality law at borders, which are also aspects of human rights law. When we talk about human rights law at borders, I also think it's important to think about human rights beyond the ECHR. In the scholarship, we have important insights from scholars like Marie-Bénédicte Dembour, offering the inter-American system of human rights as a corrective to some of the shortcomings of the ECHR in this context. Bashak Challa, Stuart Cunningham and I have recently looked at the role of UN treaty bodies, who are now very lively and active interpreters of the norm of non-refoulement, and it seems also providing some additional effective protection against refoulement, including for individuals in Europe. So really all of that is by way of reminder about the breadth and the complexity of law applicable in these contexts. In relation to the Inter-American Court of Human Rights, of course, one can pick many sort of distinctive aspects, but just as a preface to my lecture, I wanted to highlight and remind us about its advisory opinion on the juridical condition and rights of undocumented migrants, where you had this very powerful endorsement of non-discrimination and the right to equality, indeed claiming that they're jus cogens. I don't want to necessarily endorse that finding as such, but I think it's an important point of departure when we start to think about discrimination at borders in particular, and whether discriminatory practices at borders may or may not be justified. So the other aspect of law that I think is very important and productive to reflect on in this context are actually the boundaries between different bodies of law. So in relation to any exercise of public authority, normally one would expect constitutional and administrative law to be the applicable norms. And I think it's interesting to think about migration control and the extent to which migration control is often framed in some sort of exceptional way when it comes to constitutional and administrative norms and whether that's justified. But I think they're also very important insights from labour law and criminal law, which of course are bodies of law that are differently configured across different member states in Europe as well. But nonetheless, I think there are important insights to be had. For example, when we think about the way immigration laws create migration statuses, and those statuses may render people more vulnerable to labour exploitation, that they actually are very powerful insights from labour law in this context. And similarly, as we're all aware, there's now this pervasive criminalisation, not only of irregular migration, but also of assistance to irregular migrants. And I think looking at ideas within criminal law to challenge that can be quite powerful as well. The other aspect, I think, of law at borders that needs greater exploration, and here I'm echoing a plea that Nicholas Feit-Tan and Thomas Gammeltoft-Hansen made in a recent special issue of the German Law Journal that I had the honour of co-editing with Itamar Mann, is really to think about law on the other side of the border also, particularly when looking at externalised migration controls. Their account is a very rich one, but one of the examples that they put to illustrate their approach is the court rulings in Papua New Guinea, which ultimately were the court rulings that found that the immigration detention, which was effectively run by Australia or at Australia's behest in Papua New Guinea, was a breach of the human right to liberty. I think what that powerfully reminds us is that migration controls always take place somewhere, and that very often it's not the case that externalized migration controls are in a legal black hole. They're just somewhere else, and that somewhere else too has laws that are worthy of exploration. And I think as strategic actors, for those of us who think strategically about migration control, accountability and the rule of law, this somewhat obvious insight I think is also quite an important one. So these are really just comments by way of a preface to the body of the lecture, which is going to look at different sites of migration control. As I said, the one that I'm going to try to live up to in this lecture is also thinking about non-discrimination at borders, as well as thinking about other human rights norms, and just more broadly about the choices that are made about how different aspects of the border are regulated. So in this, and in this part of the lecture where I think about the multi-sided nature of the lecture, I'm reflecting a little bit on Ayla Chahar's recent work, where she's been writing a lot about, in one piece, what she's called bordering migration and the migrating borders. But in this body of work, I think somewhat intriguingly, she invites us, and this is a quote from her, that instead of a menacing obstacle and tool to restrict access to asylum, we can rethink the shifting border as a creative resource in the service of advancing human rights across borders. So her point, and I'm summarizing a very rich body of work obviously, is that because migration controls take so many different forms, they have so many different sites, that these may be actually opportunities to think more about different forms of accountability and legal regulation. So in terms of sites of migration control, I've listed about 8 here. I'm going to try to talk about 7 of them, or at least 6 of them. And really all I'm trying to do is just open up an exploration into this whole panorama of migration control. And also just think about the way different aspects of migration control are differently regulated. So I'm going to start with visa listing. So the process by which states, or in this case the EU, decide which nationalities need a visa to enter the territory of the EU. I'm going to talk a little bit about Schengen visas, but also other types of visas. So there's the listing process, number 1. Then I'm going to also talk about the application processing and how that works. Then relatedly, I want us to reflect a little bit about stratified admissions. So how there's so many different types of admissions channels, if you like, for ostensibly different kind of migrants. I can't really talk about these in detail, but so I'm going to zone in a little bit about humanitarian admissions and resettlement. But one thing we might want to start to reflect on is really how decisions are made about how to siphon different people into different migration statuses. A colleague of mine in Oxford, Cathryn, has written a really powerful thesis looking at how, when you look at how these different migration statuses siphon different people into different categories, you can actually see patterns of gender discrimination, with women often in categories that are less rights endowing than men. So I think trying to take an overview of migration categories and statuses can be quite an important exercise in and of itself. In this lecture, I'm going to zone in a little bit on humanitarian admissions and resettlement, but obviously there's lots more that could be said about any of these categories. Then I'll also just very briefly talk a little bit about asylum adjudication, which is something that I'm studying a lot at the moment with my colleagues in a project called RefMig. Indeed, we just helped to publish a special issue of the Forced Migration Review, which brings together some insights about different forms of asylum adjudication around the world. One of the things we're trying to do in that project is argue that a very individualized, judicialized process of asylum adjudication that in some ways Europe has normalized may not be the best way to go from the point of view of refugee protection. So as well as these bureaucratic processes, many of which are externalized, like visa processing, for example, we then come to a discussion about physical borders. So what happens when individuals try to cross physical borders? And actually a physical border, as we know, may also be an extraterritorialized border. It may be a juxtaposed control in an airport, or a land border which has juxtaposed controls in it. And here I want to explore the fact that borders are not only sites of crossing, but also sites of discrimination and violence. So I don't think there's anything all that insightful in saying that, but I want to think about the legal responses to that. Then sixthly, I want to turn to the practices within states. And here, I think what we see increasingly are the fact that private actors, employers, educational establishments, even landlords, are recruited into processes of migration control. In this discussion, I am going to focus a little bit about the UK experience, because I think the UK has adopted stated policies on this issue which are quite extraordinary. At least they're extraordinary in their frankness. So the UK decided that it would set about creating an environment hostile to irregular migrants, and that part of that would be to try to shut down opportunities for work or even for renting places to stay for irregular migrants. The final two I'm probably not going to talk to in much detail, but I think it's worth bearing these in mind. Of course, deportation and indeed its flip side, regularization, are also an aspect of migration control. And I think if we look at these side by side, we can also look at the very selective patterns of deportation and regularization that states tend to use, even in the EU, where we have a common European asylum system and a very legally regulated and shared set of standards around many aspects of asylum and migration. I think there's a lot to be said for fostering greater, in fact, discretion around regularization in order to encourage it. But I think just bearing in mind that those two sets of practices are the flip side of one another is quite important. I think that's also quite important in an era which tends to view deportation as the single hallmark of an effective migration policy. And I would very much want to be able to argue that regularization is also a really important aspect of migration policy, and indeed that in some instances there is a human right to a secure migration status, which should underpin regularization. Naturalization and deprivation of nationality are obviously also important aspects of migration control. I'm not going to discuss them here in this lecture, but I do think in a way number 8 loops back to the top to visa listing. So the prior question of which nationality do you have and how much mobility that nationality grants you is one that is, of course, subject to a lot of legal regulation. And indeed, if we're thinking about the EU, that's an area where, as yet, EU law doesn't really intervene very much in the discretion of the member states. But of course, it does set up very strong obligations of mutual recognition across the EU. So as I said, here I'm just identifying these multiple sites of migration control. The purpose is really to do two things. Think about how these different sites of migration control are regulated very differently. And then secondly, to think a little bit about non-discrimination in these different contexts and open up some ideas that other scholars have written about recently on these topics and try to bring them together for you today. So visa listing. So the first question when somebody wants to travel legally is, do you need a visa to visit the country or to migrate to the country that you're planning to go to? Obviously, it was not ever thus. So as Torpy reminds us, there was a world before we had passports. And as Stefan Zweig has very beautifully written, there was a world before visas. But visa requirements are really a fascinating tool to examine. And I think when we talk about externalized migration controls, there's often a tendency to focus on physical externalization. But I think looking into visa listing and visa processing is really crucial. Because for me, it's visas plus carrier sanctions create the dangerous migration, dangerous for would-be migrants and refugees, that is. That really is one of those tragedies of our times, to evoke the words of Elche Graal Madsen, actually writing in 1983. So looking at visa listing, what we know about how the EU engages in visa listing or how visas have evolved over time comes from some really important scholarship in migration studies. So this is from a 2015 article looking at how visas have evolved over time, arguing that there is now a very clear global mobility divide. The authors illustrate that in many different ways, but I think this graph is one that's quite telling because it shows the trend over time from 1969 to 2010. And overall, the argument in the paper, and it's backed up with very strong empirical evidence, is that for individuals from OECD countries, from rich countries, there is actually more visa-free travel opportunities than before. That's the general trend. So on the right, you see the countries where people have gained more opportunities for visa-free travel. Korea, Hong Kong, Brunei, and then a cluster of states that join the EU and thereby gain more global mobility. And then on the other side, you see the losers. So Pakistan, Tunisia, Sri Lanka, Uganda, Morocco, India. And as many of you are probably aware, a lot of the time the agent of this process is the EU. So when Spain joins the EU, Moroccans lose mobility rights that they previously had to visit and to work in Morocco on a circular basis. So this isn't a new story, but I think it's important to bear in mind this is the sort of reality of a global shift. We know this too from the Passport Index. So this is the global inequality in mobility opportunity, which is captured by the Passport Index. I was intrigued when I went to get the image for the screenshot to see that global mobility opportunities are now down for everyone because of the pandemic. But that's a whole other set of issues that we could discuss. So we know about this global inequality of migration opportunities. As lawyers, we may find that that kind of global inequality is really beyond our toolkit. But I want to suggest we should start thinking about whether this maldistribution of global mobility opportunities is something that we should be addressing legally. In that, I think this article is really noteworthy. Martin den Heijer has examined the EU visa listing processes and whether they can be viewed as discriminatory. Discriminatory, in this article, he's looking at race discrimination and religious discrimination. And I think importantly what he demonstrates is that a lot of the decisions about visa listing in the EU are sort of inherited from a process when there wasn't any apparent reflection on the reasons for particular states being, as it were, blacklisted rather than whitelisted. And so he argues that in some instances there could very well be legal arguments being made about the discriminatory character of these listing decisions. If anything, I think his doctrinal argument could be pushed further, but that's to get into the details of it. But I think the point in principle is just quite striking, which is that there is possibly, and I would argue probably, illegal discrimination inherent in the whole listing process for visas to enter the EU. I think the person that we should be really grateful to in this context is also Professor Tendayi Achiume, who's currently the UN Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance, because she's really using her mandate to look into this question seriously. This question being, when are border controls actually legally racially discriminatory? As well as just a more general question, which I think is also equally important, when are they, tinged with historical racism or reflective of racialized hierarchies that are inherited from colonialism. But I think the legal question about non-discriminatory borders is also one that requires increasing attention. And I'm pleased to say it is something I'm working on at the moment, but it's very much a work in progress. So that's the question about listing, which countries' nationals are being subject to a visa requirement. The second aspect of migration control I wanted to talk about was the actual processing of visa applications. Now here, what strikes me is that what I've learned about visa processing is primarily from ethnographic studies. I'm going to mention just one, which is Federica Infantino's article and also book. There are a range of other sources. But to my knowledge, but please correct me if I'm wrong, I don't know that much actual legal scholarship about visa processing. And again, that's kind of extraordinary. I mean, this is how the decision is made in the first instance about who is illegal or becomes an irregular migrant to the EU, or who is deprived of the opportunity to travel or indeed to settle in other states. So Infantino has done this very in-depth ethnographic study of the processing of Schengen visas, looking at 3 different countries' Schengen visa practices in Casablanca and Morocco. So she looks at the practices in relation to Belgium, France, and Italy. Some visa processing is contracted out to private companies and some of it isn't. Even this isn't harmonized at the EU. So there are 2 things that I glean from her ethnographic study. Of course, it's very rich and detailed, as all ethnography is, but there are just 2 points that I wanted to highlight today. The first is her central argument, which is actually that when somebody applies for a Schengen visa, which is a temporary visa, obviously, what gets you rejected is if you present a certain risk profile. And that profile, in her view, is actually that you would pose a risk of lawful settlement, that you look like the sort of person who might try to stay, even including who might try to stay legally in the EU. And if this is accurate, then that's quite a striking finding in terms of how the legal regime in practice, and she's really studying the street level bureaucrats, is doing something that it officially shouldn't be doing, which obviously from a rule of law point of view is quite a serious problem. The second aspect that I think comes through from the ethnography, and this is something that she isn't actually her direct focus, but as somebody with an interest in non-discrimination, I always find this striking, is that a lot of these risk profiles are in effect discriminatory. Sometimes they're discriminatory on grounds of gender. So she recounts, for example, that for some visa officers, attractive young women should not be granted visas because they just might meet somebody, single attractive women that is, they might meet a prospective partner in Europe, get married, settle down, and that is the kind of risk of lawful settlement that visa officers should avoid. And of course, there's also latent race and class discrimination in this profiling that takes place, this risk profiling that is part of how visas are administered. And the quote that I've highlighted on the slide is an anonymous interview that she had with somebody from the European Commission, from the visa unit. And they were talking about the knowledge that they have that the kinds of profiles that exist are not suitable to being put even in the handbook that officially guides decision makers, not to mind in the visa code itself. So that if you made it clear the kinds of risk profiles that were used, that would be problematic. In the quote it says, because the Parliament has the right of monitoring. I imagine reading between the lines that also the perspective of judicial challenges based on these grounds, or even challenging the grounds themselves legally, would be a really live issue. So in a way here you get a system where decision-making has become partly privatized, it's partly public, it's often done by local staff if it is embassies that are still doing the visa processing, but where you have a whole set of tacit assumptions that are really legally problematic. One of the most striking things about Schengen visas, of course, is that this idea that you might stay longer than your visa is the ill which we seek to avoid. So you'll get your application rejected if it looks like you're going to overstay, to put it very crudely and oversimplify. And so what that means in practice is that a lot of the time it is not just potential overstayers for family or work reasons who will be rejected, but also would-be or potential asylum seekers and refugees. I'll come back to that in a moment, because where I've taken us so far suggests that visa processing is really a process where there's a lot of arbitrariness and tacit discrimination at play, and maybe that's by design. Of course, in this day and age, it's also very tempting for states, often because there are powerful commercial actors suggesting to them that bots can do this better, that they should introduce algorithmic decision-making into these types of processes. I know this is something that's going to be discussed at the conference more, but I did want to allude to some, in a way, sort of good news from the UK. In the UK, there was a very controversial algorithm being used in relation to some visa applications. And two NGOs, the Joint Council for the Welfare of Immigrants, that I'm going to mention again later, and a smaller NGO called Foxglove, which focuses on algorithmic and new technologies, successfully led to the withdrawal of the current algorithm that was in use in relation to some UK visas on racially discriminatory grounds. And now, thankfully, I think we have starting to have a lot of NGO and some scholarly reflection on the role of algorithmic decision-making in this context. I just wanted to open that up. There are pilots for using algorithmic decision-making in other areas of migration. And really it throws up a whole lot of new questions in relation to accountability and the rule of law, and even the knowability of what's going on inside these processes. I think Petra Molnar has put this very well, because when we look at the opportunity and the threat posed by algorithmic decision-making in migration and asylum, I think we have to acknowledge that we don't really have a system of decision-making in this area that works well at present, or that has even settled norms of fairness about how decisions should be made. And to introduce algorithmic decision-making into this then just poses a whole lot of additional problems. I can talk about that a little more in the Q&A, but I wanted to just put it out there at this stage because it came to mind when I was talking about visas. As I said, from what we know, and it isn't that much actually, from the little we know about how visas work, ordinary, let's say Schengen visas, the risk of overstaying is the thing that will get your visa application rejected. And I think in every talk since 2015 I've used this illustration, which comes from the EU's fundamental rights agencies. Because what that means, if you're coming from a so-called refugee-producing country, is just, sorry, there is no Schengen visa for you. So this is how the FRA illustrated this point in relation to applicants from Syria for Schengen visas. Just this absolutely stark drop off in visas being granted as the war in Syria began. We know this. I mean, this is the story of 2015, of mass arrivals, of deaths at sea, of dangerous journeys. This is the sort of nub of that, the visas plus carrier sanction story. But what I wanted to do in this lecture is then reflect a little bit further about what then. Because I think the trope that Europe is now getting into, and it seems to be a trope very much inherited from Australia, in fact, is the fact that, well, because there are some humanitarian admission means and resettlement of refugees, that the issue about legalizing access to asylum is sort of, at least in part, being dealt with. I think thankfully we have a lot of scholarly attention on this question now in Europe. So I'm not going to go into the detail of all of it, but I just wanted to refer to the scholarship that I'm finding useful on this issue. But in very crude terms, of course, there are a whole lot of questions about humanitarian admissions practices, including resettlement. The single biggest remaining one is just the question of scale. And as long as these policies and practices only offer admission or resettlement to a tiny number of potentially eligible individuals, their workings will always be somewhat arbitrary. And I think that's what comes through in a lot of the scholarship. You know, that we're still talking about very, very small admissions programs and practices. And of course, as we all know, the attempts to litigate access to asylum through embassies and so on has been just absolutely heartbreakingly disappointing. The other insight that comes, and it's a related one in relation to how these sorts of practices work, and including, I think in particular, resettlement, is captured in a recent article by Tom de Boer and Maya-Lane Zeek, where they describe the legal abyss of discretion in resettlement. So what has struck me in fieldwork that I've done in my RefMig project with colleagues based in Kenya and also in Lebanon is just the range of different actors involved in resettlement decision making. So from NGOs who are sort of gatekeepers and think they know who the most vulnerable are, to obviously UNHCR, which ostensibly is picking the most vulnerable refugees, to the range of embassies who offer these tiny numbers of resettlement spots and are able to sometimes tacitly and sometimes explicitly, place additional constraints and criteria in relation to the type of refugees that it will consider resettling. And it struck me in all of this that although ostensibly resettlement is about the most vulnerable, or at least according to UNHCR's criteria, then in fact it's about finding the impeccable refugee, the perfect refugee. And there are different ways in which different actors conceive of the ideal resettlement candidates. This isn't to say that resettlement and humanitarian admissions aren't potentially and actually life-transforming for the refugees who get resettled or the individuals who get admitted on a humanitarian basis. But I think it's far from addressing the central question of the lack of legal access to asylum, which continues particularly in Europe. Also very interesting, and just a little plug for the Oxford Handbook of International Refugee Law, which will be out next year, and very much on a similar vein, is a chapter tracing the history of resettlement. So from the era when resettlement was numerically much more significant, so the era of Hungary 1956, the Indo-Chinese crisis, to contemporary resettlement practices. So I suppose with that section, I really just wanted to draw the linkage between normal visa practices and decision making, and then these special channels for refugees. But also in that, maybe to make a more general observation about this process of siphoning. You know, that creating additional categories, labeling them humanitarian or refugee focused like resettlement, doesn't necessarily address the wider issues in admissions policies that I think we shouldn't lose sight of. So, speaking of asylum, obviously for most refugees, resettlement isn't their mode of admission to the EU. Resettled refugees come with their status already determined, but it is asylum adjudication. So for most refugees in Europe, they have their claims adjudicated within the EU. As I said, in one of my current projects, we're really trying to work through the question of whether group-based recognition or less formal modes of recognition of refugees are in a way better for both states and refugees, coming from the starting point that these very individualized processes that we find in Europe and elsewhere in the global north really seem to be prone to just a huge degree of arbitrariness, that they're deeply problematic. In fact, in his chapter in the Oxford Handbook of International Refugee Law, Greg Arnall reviewed the empirical evidence on asylum adjudication and seemed to be edging towards a tentative conclusion that there's so much arbitrariness in asylum adjudication that really bots would be better, or that we should start thinking about technological solutions in relation to asylum. Here I'm not going to talk about the detail of asylum adjudication or asylum procedures at all, but I wanted to bring to your attention, I think, a recent study which shows some of the positive benefits of large-scale studies and technology in this area. A scholar who is now based in London at the LSE, Mathilde Emeroux, has written a book where she got access to a huge volume of decisions from the French OFPRA. And rather than doing what a lawyer would tend to do, looking at the text and the explicit reasoning in the decision, was able to code all of those decisions and find a really striking pattern of discrimination against Muslim applicants in this decision making. Hers isn't the only big, large N study of asylum adjudication. There are others, but I think this is a really interesting area where maybe lawyers and political scientists need to talk to each other more about the potentials to unroot, at least to reveal and hopefully to root out discriminatory practices within asylum itself. Now, so far we've been talking about bureaucratic processes, but those bureaucratic processes determine how the experience of crossing a physical border goes for a particular individual. So if you have your papers in order and a visa, and the papers look okay for the airline and whichever other private operator may have to check your papers for you, then crossing Europe's external borders may be a breeze. If you haven't been able to get your papers in order, or indeed get good fakes, then you may have to take an irregular mode of travel. I think one of the things that we know about externalized and privatized migration controls is that they're much more likely to be racially discriminatory. And what strikes me, I mean, I'm not saying we know that. I think that's a very plausible premise given what we know about the way migration controls work, in particular when they're privatized and externalized. What still surprises me is that there's so little legal analysis along those lines. So when I was looking into this recently and trying to think about physical border controls and their racialized nature, I still found myself going back to the UK House of Lords decision from 2004 in the Roma rights case. Again, all of the sort of cases in this area brought by pioneering NGOs. And here you had a situation where in the Czech Republic, pre-EU accession, the UK had put border guards in the airport in Prague, and there was an explicit actual instruction about racial profiling and racial discrimination against Roma, which was backed up by the pattern of empirical evidence. And in a very powerful judgment of Baroness Hale, she really argued that in operations like this, where the risk of racial discrimination is so high, the obligation was on the state to demonstrate that it had policies and practices in place to make sure that racial discrimination didn't happen. For discrimination lawyers, I think that idea that, where there is indirect discrimination or a very high risk of discrimination, that it changes the legal obligations of the public authority. I think that's quite a standard view, but I think that would really be transformative if we took it more seriously in other areas of migration control. I think on racial profiling more generally, it's striking that the leading case of the European Court of Human Rights, at least as far as I'm aware, is about an internal border check, in this case within Russia, where somebody was profiled on the basis of looking Chechen. But it's a very strong principled ruling in terms of saying that any form of racial profiling is racial discrimination and not capable of being objectively justified in a democratic society. I think if we apply that to contemporary borders, obviously there are a whole lot of practices that are problematic. I was struck again when reading on this topic that one of the best recent articles that I found was actually about the Northern Irish border, which is soon obviously to become an international border. So the Northern Irish border with Ireland. So if you cross the border, you'll see a sign like this telling you speed limits are going to shift into miles per hour, because as we know, the UK, even within the EU, had its own view about non-metric measurements being important for national culture. But in their article, Cathryn and Garcia-Blesa draw on a whole lot of studies about the fact that when you have a land border like this, where you have checks, not for everybody, but sporadic, intermittent border controls, that they bear down more heavily on people who look like they might be irregular migrants. And that idea of looking like an irregular migrant in Europe is a really deeply racialized one. So I recommend the article to you, but I think for our purposes, it's always striking to me that, in human rights law, making the argument that racial profiling is illegal race discrimination is pretty straightforward. But what we often lack is the evidence base to challenge those practices in a formal way. Or even if the evidence base exists, obviously you need to have particular types of monitoring bodies, which ostensibly we have for equality law in Europe, or particularly well-resourced NGOs in order to bring legal challenges or to bring up these practices otherwise and have them reformed without necessarily having to litigate. So the other observation, and really I'm taking a very big and massively politically important issue and just dealing with it in a very general way here, is that of course borders are not only sites of discrimination, but also increasingly in Europe, it would seem, sites of physical violence. So this, I think, is one of the really striking aspects of the pandemic, that it seems to be acting as some sort of cover for, again, a whole range of very brutal practices at Europe's borders, which seem to entail refoulement. I think the legal questions about whether, say, pushbacks from Greece, where Greece seems to be using its own form of dinghies to push people back, whether that's refoulement, that seems like an open and shut issue. So one glimmer of hope that I see in the EU Asylum and Migration Pact is a reference at least to some kind of independent monitoring mechanism at borders. And I think if that's something that can be built on, it can be quite important. So finally, I wanted to allude to checks within states. Now these exist in EU law in a way because we have an employer sanctions directive and we have other measures which effectively mean that migration status becomes a relevant marker for the enjoyment of other rights and entitlements within states. So migration status travels with migrants. It's not just a matter of control at the border. The set of practices that I wanted to problematize here relates to what the UK dubbed its hostile environment. It came up with this name for a set of practices to make sure that irregular migrants went home or could be deported, so to end overstaying. It ended up deporting people who were effectively British nationals, being overtly racist, and being challenged in many different aspects. And in fact, in the quote here, which is just by way of background, in one of the original discussions about the hostile environment, one of the people at the relevant cabinet meeting actually told David Cameron that requiring landlords, for example, to conduct immigration checks was a bad idea, and that anyone foreign looking would face challenges accessing private rented accommodation. So I think that insight is pretty obvious. It was obvious to the people who created this practice. What's been interesting to me is how many aspects of the hostile environment have been legally challenged. And again, from the point of view of discrimination law, I was quite excited when I saw that in the UK High Court, the checks which landlords were being asked to carry out were found to be so likely to lead to racial discrimination that they were unlawful on that basis. So that argument, evocative of the point that was accepted in the Roma rights case, that if you set up a system which has a very high risk of being racially discriminatory, that system has to be legally checked, seems to be applicable here. Unfortunately, on appeal in the Court of Appeal, that argument was rejected, and I understand the case is now under appeal to the UK Supreme Court. But I'd be very interested in the discussion to see how you think a case like that might go in the German context, with German constitutional protections at play. So what I've done in this part of the lecture is really point out how multifaceted and multi-sided migration controls are, and that different facets of the border are regulated very differently. Some aspects of it are contracted out, are privatized, are externalized. Some aspects of it are reach deep into our host states. And I think in all of this, the question about discrimination is a live one, in particular, when we think about the way that migration controls, really at all levels, are potentially racially discriminatory. And also, if you imagine the way that migration control creates a status, which is really an indelible status that individuals have when they live in host communities. And if that is racialized, because migration controls are racialized, then we're really setting up a very divisive set of practices and policies for the countries that we live in. So really what I've set out here is a massive rule of law challenge. There's a rule of law challenge because of highly discretionary policies and practices. And then an even bigger rule of law challenges because those policies and practices lead to a situation where individuals who get deemed to be irregular migrants have a whole range of different adverse consequences meted on them. So it's not just that an irregular migrant is somebody who does not have a permission to live in the country and may be able to apply to regularize their status. It's that an irregular migrant may, particularly in systems like the UK's hostile environment, have a whole lot of other legal disadvantages imposed on them and may also, in many European countries, be criminalized. So this is the rule of law challenge. Rule of law redux would be, I guess, just working through each of these sites of migration control separately, because that's all we as lawyers can really do, and bringing as many different legal tools to bear, effectively to regulate these questions differently. I don't think there's any inherent reason why migration controls have to be regulated in this way. Some of it is historical accident. Some of it is the inheritance of a certain vision of European superiority and a legacy of colonial relations. Some of it is just predating an account of the rule of law and accountability that we find in other areas of public administration. So obviously there is a big sovereigntist narrative around migration control, but we all know that that's just a diversion from really an area where states routinely have to engage with outsiders and decide who can live legally in different legal communities for how long, and that those decisions could be made with much higher adherence to the rule of law. To conclude on the point that I had suggested, that we can also start to think about the conduct guiding function of the rule of law, I do think thinking about refugees more, and would-be refugees in Europe, is still of critical importance. One of the most striking things for me about resettlement, and particularly if we focus on resettlement as the safe and legal mode of accessing protection in Europe, is that the refugee doesn't even get to apply to be resettled. They're not even the applicant in a process. They are just the subject of an assessment of vulnerability that a whole range of different public, private, and international actors are making. And I think for me that really sums up the fact that we are not treating would-be migrants and refugees as proper subjects of the law who can make decisions about where they want to live. And to me, this is still at the heart of the injustice of the European asylum system, the fact that you have to choose, for most people, to choose to break the law and risk your life in order to gain protection in Europe today. So I look forward to the discussion. I'm also greatly looking forward to joining you for some of the conference over the next 2 days, and I hope I've set up some interesting provocations and point for discussion. Thank you.